Hello everyone, welcome to the Pan-African Law Society's first event. It is called PALS Speak, and we just want to quickly do some, order of event things that we need to know in case of a fire. We have fire exits at the back of the theatre, there and there. And then we have one here as well. So if the fire alarm does go off, we need to leave the building in an orderly fashion. As soon as and safely as we can. So we're just going to get on with the event. The first thing that we have is an introductory note from the President of the Pan-African Law Society. So he's going to come and give a very brief introduction to what Pan-African Law Society is all about. So come and welcome Dimeji to the front.
Thank you everybody for coming out to that today. This event couldn't have been possible without all of you here. Firstly, with the Pan-African Law Society, I think it's pertinent that we establish what Pan-African is, because we've had questions over time what Pan-African really means. Some people attach ISM to it. It's not Pan-Africanism, it's Pan-African. That's to suggest a collection of African countries moving for our objectives, nothing more than that. I think it's key to point that out at this point in time, because this is the Convening conference and we want everybody to understand where we're going with this. The PALS Speak is a unique event that I think should have been established prior to now, because I think we don't have enough platforms as Africans to discuss ideas for the development of the continent. And Africa as a continent is key to global development, because with enormous resources, and right now Africa is home to a lot of emerging economies. So Africa is really central to global development. So although we say Pan-African, it's actually central to global development. PALS Speak is the platform we seek to use to discuss these ideas. We have today Godwin Obla. He's a senior advocate of Nigeria. He's when we say African legal luminaries, we particularly talk of people like this. African legal luminaries, not in the sense of, I know he's a senior advocate, but it's more of his achievements and where he's put his strengths into. Godwin Obla has been a frontline prosecutor for the EFCC, and has been a major player when it comes to the fight against anti-corruption. That's why we have him here today. As we get the direction of the society, we have at the back of the pamphlet, we have the vision of PALS, just to show you programs and activities we plan to use to attain our objectives. The vision of PALS, as encompassed within our motto, is law for development. Law for development is on different layers and on different platforms. It's not just development in the sense of a student society. It goes from personal development to academic development to national continental development, and also globally too. This is why our society is established, and through our different programs we hope to achieve these aims. So I hope everybody here can really enjoy this event, and we plan to host many more. Thank you very much.
Open our horizons and help us understand more about development in Africa and how improvements in law and fighting against corruption can actually affect not just Africa but the world as a whole. Because as we all know, Africa is full of resources. So that's why we have our speakers to come and illustrate those to us even more than, you know, we can talk at you for the whole hour, but once you actually hear how people have, you know, fought corruption, will make you understand more what the Pan-African Law Society is all about. So we had some speakers planned to come tonight, but unfortunately she couldn't make it. So instead she has sent us a video. This was, she's a representative of Dr. Lisa Abakoba. Abakoba, I'm saying that right. Yeah, so this is a goodwill message, so we're just going to play the clip.
Good afternoon. My name is Dr. Wilfred Mama. I'm the head of the Development Law Group of the Lisa Abakoba Legal. With me here are these are colleagues in the Development Law Group of the Lisa Abakoba Legal. We would like, on behalf of the senior partner, Dr. Olisa Abakoba, and the law firm, to congratulate you for the excellent group you formed at the University of Leicester, the Pan-African Law Group.
All right, in that case, we're going to move on to the next. So we have a keynote speaker who is Godwin Obla, as described earlier by Dimeji, and he is a pioneer in the persecution of those involved in corruption in Nigeria, and we thought it would be really good for him to come and give us a speech. So if we can welcome him to the stage, look enthusiastic, you know, if we're here to learn, okay? Welcome him.
Good afternoon, ladies and gentlemen. I'm happy to be here today. It took a lot of persistence on the part of your president to get me here today. But I think coming from my background, having left the university in 1983, I'm sure most of you were not born then, I believe platforms like this will be very important to encourage young aspiring lawyers not to look at the greener side of practice, but at those aspects of practice that can help the society. I think the biggest challenge to the African society today is the challenge of corruption and how to deal with it. Notwithstanding the abundance of laws that address this scourge, the impunity with which the acts continue to be carried out requires that more hands be on deck. I'm sure after looking at some of the figures today, figures that I call sovereign figures, a lot of you will be willing volunteers in this fight. The topic selected by your association is a very important one for both developing and advanced economies. The nexus between law and development is an ever-present one, and an understanding of the relationship between both concepts is indispensable to an assessment of how law institutions can be used to foster the desired change and to achieve national and international policy goals. The elimination of corruption through the instrumentality of the law is linked to development in a variety of ways. Eliminating corruption is promoted to avoid squandered resources, to promote security and accountability, inspire confidence in a nation's economy, and to lead to an efficient and equitable distribution of resources. The true impact of corruption, bribery, money laundering, and other similar vices transcend their monetary value they weaken a state's accountability to its citizens. Long-term impacts also include lost opportunity for investment in development, alleviation of poverty, and human suffering. If you look at the statistics, the World Bank estimates that for every $100 million of recovered money, treatment can be funded for 60,000 persons living with HIV and AIDS for a full year. 50 to 100 million people can be treated for malaria. 250,000 persons can have waters connected to their households. And immunizations can be undertaken for 4 million people. It is for this reason that I've approached this paper from the angle of impact, whether actual or constructive, of the recovery of illegally obtained funds and assets, otherwise referred to as process of crimes, on the economic development of the state. The paper will focus on the Nigerian experience in the fight against financial and economic crimes, both of a domestic and extraterritorial nature, with particular emphasis on the recovery of monies and assets proven to be identifiable process of crime. Let the point be made, however, that corruption is not exclusively a Nigerian or indeed an African problem. It remains a pervasive problem in more advanced economies like the US, Russia, Czech Republic, Italy, as it is in parts of Africa and Asia, even if to an admittedly lesser degree. Now, to Nigeria as a background. Corruption is a complex social, political, and economic phenomenon. There is no single universally accepted and comprehensive definition of corruption. Attempts to develop such a definition invariably encounters legal, criminological, and in many cases, political hurdles. However, for operational purposes, corruption can simply be defined as the misuse of entrusted power for private gain. Robert Whitgard has summarized the key ingredients of corruption in the following simplified formula. Corruption is equal to monopoly plus discretion minus accountability. Simple definition. In other words, the opportunity to engage in corruption increases with the degree of control government officials and politicians have over goods or other assets valued by the private sector, and with the degree of discretion the officials and politicians have in allocating those things. Cross-border corruption may be defined as corrupt practices afflicting both private and public sectors, which transcend national geographical territory, in contravention, of course, of national and transnational laws involving individuals, or the corporate, and in some cases, politically exposed persons. The examples abound: embezzlement, nepotism, bribery, money laundering, misappropriation, mismanagement, gratification, bid rigging, amongst others. Nigeria as a country is perceived as having one of the most corrupt public service sectors in the world. Its transparency rating is at a low 27%. In 2013, Nigeria ranked 144 on the Global Corruption Perception Index. This problem is, however, not restricted to the public sector alone. There have been several cases of embezzlement, money laundering, and corrupt practices in financial institutions and IOCs, the international oil companies, amongst others. The discussion here will focus on one instance each from the public sector and the private sectors. The case of General Sani Abacha will be for the public sector, and the case of Mrs. Cecilia Ibru will be for the private sector. As far back as 1999, the UNODC, which is the United Nations Office on Drugs and Crime, had estimated that about $400 billion had been plundered from Nigeria's coffers since independence in 1960. Most of these monies remain unrecovered. According to Tim Daniel, the country director of UNODC at the relevant time, the figure for the amount looted from the treasury annually stood in the region of about $110 billion annually. This is the graphic way he actually described what happened in Nigeria. That is a staggering, almost astronomical amount of money. Because if you were to put $400 billion bills end to end, you could make 75 round trips to the moon. Concretely, this $400 billion would have been translated into millions of vaccinations of children, thousands of kilometers of roads, hundreds of hospitals, and water treatment facilities that never came to be. Now, if you take the case of General Sani Abacha, is alleged to have looted between 3 to 5 billion pounds sterling from the public till between 1993 and 1998, when he held sway as the head of state. This amount represents a staggering 3% of the national GDP at the time. To put this in proper perspective, in 2009, the budget for the establishment of a fully equipped International Cancer Center in Abuja, the Nigerian capital, stood at the comparatively paltry £40 million. At £5 billion, therefore, the Abacha loot was sufficient to establish 1,250 of such centers. Also, according to a 2012 report by the Global Financial Integrity, a Washington-based anti-corruption organization, $129 billion flowed out of Nigeria over a period of a decade through crime, corruption, and tax evasion. While it may be difficult or indeed practically impossible to give an accurate estimate of the consequences of official corruption on the critical sectors of the economy or the developmental deficit that resulted from the sustained pilfering of the nation's resources, one can safely conclude that Nigeria would have benefited immensely, infrastructurally, and even in human development terms, if all her resources were applied for the benefit of her citizens. One of the reasons are due for the impunity that characterized the Nigerian public sector is the apparent inability of successive governments to muster the political will to curtail the excesses of government officials, as well as the absence of probity at the highest level of government itself. The most compelling argument for this state of affairs was allowed to fester over the decades, however, seems to be linked to the perceived inability of the law and Nigerian law enforcement agencies to deal decisively with these issues. Obviously, for this reason, the government of General Obasanjo in 2000 and 2003 respectively set up two institutions, the Independent Corrupt Practices and Other Offences Commission and the Economic and Financial Crimes Commission, to tackle the menace of corruption. The efforts of these institutions and the impact on development will be discussed later. But notwithstanding the existence and the operations of these institutions, corruption continues to be a huge problem in the country. I would just discuss a few recovery efforts that have been made in respect of, or by these institutions, and juxtapose it with the existing state of things to see how far we've gone. Since the return of democracy to Nigeria in 1999, concerted efforts have been made by successive governments to recover illegally acquired funds and assets. Some of these appear below. In Abacha's case, he was reputed to have stolen about £5 billion. In some cases directly, he would just ask the CBN governor to send the monies in cash, and the monies would be withdrawn in cash. In some other cases, he would use proxies, or contracts would be inflated, or generally just embezzle the money. Most of these monies were stashed in foreign accounts held by family members, proxies and colleagues in the US, the UK, and Switzerland. In 1999, the government initiated the process of recovery. 10 years later, and after protracted legal and diplomatic battles, an estimated $1.3 billion has been recovered and plowed back into the economy. The first major recovery took place in 2005, that is 6 years after it started, when the Swiss government returned the sum of $505.5 million US. There was a caveat to the return of the money because the Swiss themselves had doubts as to whether, if this money was returned, it wasn't going to be recycled back the same way it was actually stolen. So they had their doubts. So they needed to put in place the mechanism to ensure that the monies were appropriately applied. So what did they do? They insisted that the money should be expended on pro-poor projects under the supervision of a neutral party. And because the Nigerian government desperately wanted the money, they conceded to those conditions. And they told the neutral party appointed by the parties was the World Bank. In order to apply the money in accordance with the agreed formula, the Swiss government went for that through the World Bank to provide a grant of $280,000 US to co-finance the Public Expenditure Management and Financial Accountability Review Program, which focused on reforms in budget spending with regards to Nigeria's national economic priorities in education, health, and basic infrastructure, essentially power, roads, and water. These sectors were chosen by the Nigerian government based on their potential to help the country move towards achieving the Millennium Development Goals. As a result of that, the first tranche of the recovered Abacha loan, which amounted to $505 million US, was applied as follows. Education got about $60 million, health got about $180 million, water got about $42 million, works got about $140 million, and the power sector got about $160 million. A Nigerian civil society organization, Integrity, was selected by the World Bank to monitor the use of these funds. In fact, these projects were executed so well that in 2012, the World Bank Asset Recovery Handbook described it as a classic example of how to use recovered assets for the public good. On the 25th day of June 2014, Nigeria received another tranche of $225 million of the Abacha debt from the Principality of Cheif in Europe, which had been frozen for over 16 years. The government immediately established a committee headed by the Minister of Finance, to identify the best projects to disburse the retrieved funds once again under the supervision of the World Bank. So the World Bank had to babysit the Nigerian government on how to apply these monies, because people still believed or had their doubts as to whether these monies would not be stolen a second time around. Right now, the US government has frozen more than $485 million hidden in various accounts scattered around the US, even as it continues to trace an additional $100 million in holdings within the country. These monies were also traced to the late General Sani Abacha. The problem that is likely to happen in the US is that the US may not behave like the Swiss. The US believe that monies that are stolen are like a cash cow for the US economy. So they will mostly seize the money and never return it to the country that lost the money in the first place. And we have a recent experience with the US in respect of the Halliburton bribery monies. The last batch of the money that was remaining in Switzerland was $140 million. It was money appropriated for bribes to be given to Nigerian officials in respect of projects that were domiciled in Nigeria. Right now, the US government, through the DOJ, the Department of Justice, arrested one of the individuals involved in the bribery scandal. I'm sure if you have read about one Jeffrey Tesla, he's worked out a deal with the DOJ, and part of the deal was he was going to forfeit the $140 million to the US government. But the money didn't belong to the US government. The US government had no connection to that money, except for the fact that US companies were mentioned. The money rightly belongs to the Nigerian government, because it was in respect of contracts in Nigeria that were overpriced by that amount, and the amount skimmed off to be given back as bribes. But now the US government has seized the money. And I'm sure every effort the Nigerian government will make to get it back will be futile. Now, that is what we have to say about the public sector aspect of corruption. I really don't want to dwell too much on the public sector as well, because there's so many of them. I'm sure if you just Google corruption in Nigeria, you'll see so many of them. The private sector aspect, because there's always a tendency for people to look at corruption as being restricted just to the public sector. No, the private sector is very much deep neck in it too. For the private sector, we'll just look at the case of Cecilia Ibro. It was a case that occurred in 2010 when the immediate past governor of the Central Bank of Nigeria, Sanusi Lamido Sanusi, was made the CBN governor. He actually came into that office with a different perception, because he was a risk specialist in the banking sector as executive director in charge of risk management in First Bank and executive director in charge of risk management in UBA. So he knew the deals the boys were doing in the bank, and he made up his mind that he wanted to sanitize the sector. So he moved in very quickly and did an audit of the banks and found out that 5 banks were irredeemably sick as a result of the underhand activities of the chief executives of those banks. And that was why there was a move against Oceanic Bank, PHB, Finbank, I think some 2 other banks. They moved against them and investigations were now conducted. In the course of the investigations, prima facie cases were made against the leadership of those banks, and they were charged. In the case of Oceanic Bank, Mrs. Cecilia Ibro was in charge, and she was charged for a variety of offenses. However, there was no need for the matter to go to trial. I think good sense prevailed. Mrs. Ibro and her advisors, after looking at the proof of evidence in the matter, felt the settlement was better. The prosecution team, I was a part of that team, also felt that it may be better for the matter to be settled so that we can save the state a lot of money, but at the same time also recover a lot for the state. So a settlement was made in 2010, and the court entered it as a judgment of the court. The initial 25-count charge against her was reduced to 3 counts. She pleaded guilty and she was sentenced to custodial sentence for 18 months, but running concurrently was going to be for 6 months. But she also now forfeited a long list of assets, I'm sure. I don't know whether you all have the papers. That's the beginning. Those of you that are Nigerians, if you look at the list, if you look at the location of the properties, you will see that they're the most expensive parts of Nigeria. And if you look at the beneficiaries, you can see that there are all sorts of proxies, all sorts of names there. You can see the continuation. Ikoyi and Victoria Island are the most expensive real estate locations in Nigeria. Now, there are some transnational aspects to it too. These are properties in Dubai too that were located. From number 37 on that list, all those properties are in Dubai. All those properties continue to be in Dubai. Next list continue to be in Dubai. Now these are shares in companies that they're going to see next. If you look at the numbers for the shares, you can see the volume. Some of the shares are up to 1.6 billion in some of the organizations. So when you look at the name of the beneficiaries, you can understand why prosecutors have a lot of problems. The beneficiaries are so many. So when you want to draw up an agreement that forfeits some of these assets, it becomes a huge nightmare. These are shares that continue. These are shares. When you look at some of these shares, you can see Union Bank is 3 million shares, First Bank 202 million shares, First Bank 25 million shares, First Bank 60 million shares. If you know the value of First Bank shares in Nigeria, you know how much this thing translates to. Now, the total assets recovered from Mrs. Ibro then amounted to, in the aggregate, 191.4 billion naira. As of then, it amounted to approximately $2 billion US. That is just one Nigerian, and she's not known to be among the first 10 or the people who are actually engaged in these practices in Nigeria. So you can imagine the damage to the development process in the country if this money wasn't recovered. Now, the essence, the strategic importance of the recovery of this money is that the five sick banks were now recapitalized using public funds. It costs the Central Bank of Nigeria approximately 5.7 billion naira to recapitalize those banks. Under the laws, the amount forfeited by Mrs. Ebru was to go to the federal government. But you know, if it goes to the consolidated revenue account, it will not be shared by the 3 tiers of government. So there will still be a deep black hole of 5.7 trillion naira that the federal government will still have to account for. However, as part of the plea bargain, what we did was to now vest these assets for the benefit of the Asset Management Company of Nigeria, which was created as a result of this development to take over the toxic assets of the five sick banks. So for the very first time, these assets were not forfeited to the government of Nigeria, they were rather forfeited to an institution that had the beneficial interest in those assets. Now, the recovery of assets in respect of Cecilia Ebru and Nigeria just goes to show, thank you. It just goes to show how difficult it is to actually, in a conviction-based criminal justice system, how difficult it is to recover assets. Now, the way the legal architecture is structured in Nigeria, unless you convict somebody, you cannot seize the assets. You cannot recover the process of crime. A lot of efforts have been made to get the National Assembly to pass a non-conviction-based asset recovery law. But they've resisted it so far because they believe that a law may be applied on some of them. So far, they've been able to resist it. And because of that, the smart prosecutor who has to recover money knows that the best way to do is just have a settlement. Of the 5 cases that were taken to court with Mrs. Ebru in 2010 at the Federal High Court, it was only about 6 months ago that witnesses were taken in one of them. The typical situation is they hire the best lawyers, the best defense attorneys, and they file all sorts of processes to frustrate the trial. And for the most minute disagreement, they will have interlocutory appeals from the High Court to the Supreme Court. I'm sure some of you have read about the case of Joshua Dare, the former governor of Plateau State, who had a problem in England some years ago. I think in 2000 he came here and he was released on bail. He jumped bail. He's never returned back to England. All attempts to prosecute him in Nigeria since 2010 has met with all sorts of legal obstacles. Just last week, the Supreme Court finally said, go back to the High Court and stand your trial. That's almost about 15 years later. During this period, witnesses have died. Documents are missing. The prosecutor is so tired and underpaid, he decides he doesn't want to be part of this any longer. So everything just goes bad. So we felt the best deal, have a deal, take the $2 billion. It may not be the best deal. She takes 6 months in the hospital. She had a bad heart during the period anyway, so it was a good excuse for us to justify it on that ground. It was going to die. We didn't want her dead anyway, we just wanted the money. It was fine, so we did that. Of course, Nigerians were asking for blood. We didn't want blood, we just wanted the money. So we've taken that. 5 years later, I think we have been justified in the decision we took. It was a good business decision, had nothing to do with emotions. The government obviously has finished spending the money, and everybody's memory is now short. So we're not looking for the other guys. Meanwhile, the other assets that we have not been able to realize from the other guys, properties and other things, are dissipating. If we have not recovered 191 billion 6 years ago, and I recovered it this year, the actual value would have been $1 billion. Because the value of the local currency has dissipated. So it can be a very, very difficult decision, but I think after the time we took it, it was the best decision in the circumstance. Utilizing recovered funds, secrecy, potential development, and the future. The Hebrew saga was not laid to rest upon recovery of the process by the government. On the application of a pressure group in 2010 to a federal high court judge in Lagos, the EFCC was given a 72-hour ultimatum, and also the governors, to make available the total value of cash and properties recovered from Oceanic Bank CEO then to the public. As needless as this controversy was, the order had actually been made. Sadly, it just showed how the population really doesn't understand the workings of the judicial system there. I mean, the order of court was very clear. The money was going to be forfeited to AMCON, not to the federal government. So it wasn't just lose money that anybody could still steal, but it shows how skeptical the Nigerian public is about everybody. I mean, even if you had delivered the money to their home to actually look after, somebody else will still raise an issue that they suspect that money is still missing. So, be that as it may, there are still valid concerns about the success of efforts to investigate and recover stolen assets and employ them for development. There's little transparency when high-profile officials are being prosecuted, even more so how the recovered assets are managed. Recently, we did, I'm sure a lot of Nigerians are aware of the Halliburton bribery cases and the Siemens bribery cases in Nigeria that had to do with the LNG plant. For about 14 years, none of those cases was investigated. So, about 2 years ago, we decided to see what could be done about it. And it turned out that there were so many names on the list, and it will really require a lot of courage for you to actually prosecute those kind of matters. You may be prosecuting a matter and additional information comes and it turns out that somebody very close to you is on the list. It has happened severally. And when the first charge was filed in court, there was a lot of confusion in the country. And